This short video provides a 5-minute explanation on key data results from our March 2025 snapshot. It provides a useful commentary on the trends and insights we are exploring as we continue to gather and analyze data on our service. We have also included some relevant discussion questions for you to consider as we continue to collaborate on our data collection and social impact as our service continues. We hope you find this useful as you consider our snapshot data and recommendations for reform. Our client survey helps us to understand whether Merit's assessment service influences a client's decision to lodge an application after receiving a no merit advice. Our data shows a clear pattern. At the initial stages, 73% of clients, almost 3/4, did not lodge or continue with their application after we assessed them as having low merit. At the appeal stage, however, this number is much lower, with only 21% of clients choosing not to continue with their application after receiving our advice. However, we did expect to see this difference. Most clients in the appeal backlog have already lodged their application for review before receiving legal advice from our service. Choosing to withdraw at this stage would require them to take an extra step without any clear incentive to do so, making it less likely they would withdraw their application. In contrast, at the initial stage, the home affairs stage, clients often receive advice before lodging, making it easier for them to decide not to proceed based on legal advice. This highlights the importance of early intervention legal services. By providing advice earlier, we can support better decision making and help prevent unnecessary lodgements, as well as providing us with an opportunity to educate potential applicants on the law and the complex processes involved. We are also collecting information on why clients choose to lodge even after receiving advice that there is no merit on their claim. This dataset is very much in its infancy and based on a small sample size, but we think it's important to share as it provides an indication of what we are hoping to achieve, whilst giving us useful insights into client decision making. Continued funding and support towards our data strategy will enable us to build and strengthen this dataset. This would help us to better understand the factors contributing to the backlog and how we can best support a more efficient visa protection system. When we look at the reasons why clients continue to lodge, we see some differences between the initial stage and the appeals stage. For initial matters, about 1/3 of clients decided to not lodge, and an additional third chose to seek further advice to better understand their options, but also had not lodged an application for a protection visa yet. Around 14% were eligible for alternative visa pathways. At the appeal stage, the reasons for lodging after receiving advice that there was no merit on their protection claim, we see 18% lodged their appeal to remain lawful, and 12% said that receiving on no merit advice influenced their decision to not lodge their application for review. Whilst this dataset is still in its early stages and based on a small sample size, it is giving us useful insights into client decision making. It is therefore important to continue to collect this information so we can work more closely with decision makers and stakeholders within the protection visa system to better understand the causes for the backlog and contribute to real long-term solutions. We've put together some questions to help guide future discussions toward a collaborative approach to addressing the backlog problem. How did the backlog numbers change during earlier periods when early intervention funding, like IAAS, was in place? From our review of data from the Department of Home Affairs, since the recent rollout of funding for legal services, we can see that lodgements for initial protection visa applications have reduced, and there is a reduction in unprocessed matters overall. It will be beneficial to consider this data in more detail to better assess the impact of funded legal assistance nationally. What unintended impacts might we see if early intervention funding is reduced or discontinued? Will the backlog numbers grow with the reduction in availability of early advice, helping clients make informed decisions? And what broader systems level solutions could help sustainably reduce the backlog and improve efficiency? We are looking forward to working with decision makers and stakeholders within the protection visa system to explore ideas that can lead to long-term positive change.